I'm Deborah from the Chicago MBDA Export Center, and this is day 2, and you will learn how to trademark like a boss. What we do is we help minority businesses that are looking to export their products and services to Africa, and this year we have been bringing a series of training to help you grow and develop your business. So we have Radiance. I'm going to let Radiance introduce herself and then at the end of this, the presentation, the workshop, I'll tell you how you'll be able to see the video in the future, and I'll do all of that at the end. So Radiance, go ahead and take it away. Radiance, if you're talking, you're still muted.
Okay, yes, sorry.
Okay.
Hi, everyone. I'm Radiance Harris. I'm so excited to be here. Today, we are going to be talking all about how to trademark. So if you were at Tuesday session, that session was primarily going through the basics of trademarks. Today, we're going to really get down to what I call the nitty-gritty and learning more about what the process entails, what to expect when you're going through the US trademark process. And so just to tell you a little bit about myself, so I am the founder and managing attorney of Radiance IP Law. We help emerging businesses protect, monetize, and grow profitable brands with trademarks. I've been doing trademark law exclusively for over a decade now. I started my career at the world's largest law firm, helping Fortune 200 companies protect their brands. And after working there and realizing that there was a really big lack of education among the small business community about the importance and value of trademarks, I decided to switch gears from helping the big corporations to helping the small business owners protect their brands so that they can focus on growing their businesses and scaling and creating an impact in the marketplace, knowing that their brands are protected. And in case if you want to connect with me outside of this presentation, feel free to connect with me on social media. If there's any soundbite or gem that I dropped today that you just feel so inspired to share, be sure to use the hashtag #TrademarkLikeABoss on any of these social media platforms. Okay, and before we dive in, I have to, of course, do a disclaimer and let you all know that this is just for educational and informational purposes. Anything discussed today does not constitute legal advice, should not replace hiring an attorney, and it does not create an attorney-client relationship or create attorney-client privilege from this presentation. So, did you know that your brand is your most valuable business asset? Just about all businesses have trademarks. All businesses have trademarks, but only a handful of them actually protect them. A small percentage of businesses actually protect them. And we're going to go into that a little bit later as to why you should and how to do it. Forming a business entity is not the same as getting a trademark. So when you go to your Secretary of State and file for your LLC or your corporation, and it's done, within 5 days, that is not the same as getting a trademark. Business entity only establishes you as a recognizable business in the state that you do business. It allows you to open a bank account and things and so on and so forth, but it does not establish legal ownership and protection in the actual name or brand that you are building. And also, neither securing domain names nor social media handles gives you any trademark rights. Oftentimes, business owners, that's the first thing they do. They come up with the name, they run to see if the domain's available, and they think that they're in the clear. That, unfortunately, is a myth. Securing domain names and social media handles does not do anything for you in terms of helping you secure actual legal ownership in the name and the brand that you are building. Also, a trademark is a key part of growing your business and maintaining your customers' trust. So when your prospective clients and customers see that trademark, see that brand, they know what to expect. They know what it means. They know the quality of your products and services. So it speaks volume to your customers on so many levels. And then most importantly, when you secure a US federal trademark, no other company can enter the market and use your identity to sell their products and services. So you are able to be the exclusive rights owner in that name, in the marketplace, in the United States. So today we're going to, if you were here on Tuesday, I'm gonna do a quick brief overview about what trademarks are for those who weren't here on Tuesday. Then we're going to go through helping you identify your own trademarks. So a lot of times you might have multiple trademarks that you might not be aware of that will need to be or should be protected. Then I'm going to walk you through how to do an initial search through the USPTO website. Then I'll walk you through what the preparation and filing of the trademark application looks like. Then we'll talk about, okay, once you do become a US federal trademark owner, what are your responsibilities? What does that look like? And then we're going to add on a little bonus where we're going to talk about filing trademarks internationally and what exactly that looks like. Also, feel free if during the session you have any questions, feel free to drop them in the chat box and I will get to them as I'm going through the presentation. So please don't hesitate to ask any questions that may arrive while I'm speaking. Okay, so step one, let's go into understanding your trademarks. And I would encourage you to definitely get out your pen and paper because I'm going to be dropping some serious nuggets. So it's going to be a lot, but I want you to, stay on track the best you can. Okay, so at a high level, a trademark is any word, phrase, symbol, or design, or a combination of those things that helps distinguish your products and services from those of a competitor. So a trademark can encompass words such as you see here. It can include your taglines, like just slogans like "I'm loving it." Sounds can be trademarked, symbols, letters, numbers can all be trademarked. So anything that serves as a source identifier for your products and services. So anything that is your unique identifier for you and your products and services can be trademarked. So that's just something to think about. We will go through an exercise, we will go through and identify your specific trademarks. So the types of trademarks that we have, so there are oftentimes you'll hear the word trademark and then you'll hear the word service mark. Those are actual, and they're pretty interchangeable. I would say formally speaking, the term trademark is used to designate the use of in connection with products, where a service mark is used to designate in connection with services, but they're pretty much used interchangeably. A certification mark is basically used by a third party to certify the quality of another's products or services. So that's what a certification mark is. So a great example of that is the Energy Star certification mark, where they will certify that certain appliances are energy efficient. So that's a type of trademark that you can secure. A collective mark is a mark that will cover a certain collective or membership. It's basically like a membership mark where it deems that you are a member of a certain collective. And a great example of that is the National Association of Realtors. That's a collective, that is collective mark that anyone who is an actual realtor can use to designate their membership in that association. And then we have design marks, which are essentially logo marks. So on this slide, there are a number of examples of logo marks here, where it's incorporating, sometimes it might incorporate words, it might incorporate a design, a word in design, just a design, stylized lettering. All of those would be considered what we call design marks, or in other words, could be called a logo. And then lastly, we have trade name, which is the use of what name are you using in the marketplace as your trade name. So why are trademarks so important? It's because they distinguish you from your competitors. That is like the primary thing, is that it helps consumers make easy and educated decisions about who they want to do business with. And on the other hand, it distinguishes you from your competitors. But then it also protects the goodwill and the money and the investment that you've put into your business, because it would actually, be very financially harmful to you to find out that there is somebody else in the marketplace with a similar name doing what you do, and you're losing money from it. So just to give you an example of this, I would say last year I had a prospective client come to me, and she was saying how she'd been using a name for 5 years, and realized that there's somebody in her state who has the nearly identical name and is doing exactly what she's doing, to the point that it's created confusion where she was receiving checks for the other company, for the work, I guess, that this other company was doing. She was receiving checks, so their checks. And so that's what I mean by like confusion in the marketplace, where it could be detrimental financially to your business if not only consumers, but business partners aren't able to distinguish your business from that of a third party. So that's what a trademark does. It is a very valuable property asset for your business. It can be sold, it can be licensed, it can be transferred, just like real estate. So that is actual property that can add value to your business and then can be transferred and leveraged in other ways to make money. And then the very awesome thing about trademarks is that they never expire as long as you're using it. So as long as you're using it, you will have those trademark rights. And as long as you are filing the necessary renewal paperwork with the USPTO every 10 years, you will maintain that trademark registration. So the two primary goals of trademarks, as I mentioned, and just to highlight here, are to safeguard the public from deception, deceit, confusion, and then to protect the energy, time, and money that you've used in promoting and building and establishing your brand and reputation in the marketplace, and preventing other people from misappropriating off of your goodwill and hard work. So these are the two primary goals of trademarks. So there are two ways to establish US trademark rights. So right now, if you haven't secured any protection for any of your trademarks, you have what's called common law trademark rights based on use alone. So if you're located in Chicago, Illinois, for example, even though your business has a national presence, you would only have common law rights in the state of Illinois. So that means you would have no legal recourse against anyone who started a competing business using your identical name or logo in any other state in the United States. So you don't have any legal recourse. You could prevent someone from popping up in Illinois, possibly, but you couldn't prevent someone else from popping up in other states. And when you really think about the world we live in, which is like extremely digital world. So think about, we've got the internet, like you've got websites. A lot of us are on social media. So even though you may have what's considered more of a local business, you're not really local, because people can still find you on the net. People can still see you on social media. And so in that regard, you're definitely exposed and vulnerable because of the digital world that we live in today. But right now, without a US federal trademark registration, you would have what's called common law trademark rights. However, if you go and pursue and get a US federal trademark registration from the US Patent and Trademark Office, then you would have exclusive nationwide ownership and protection in your trademark across the United States. So it does not matter at all, you know, who else might be using it if they don't have a federal trademark registration. That is what trumps everything else. And so we will walk through today what that process entails. So why do you need a trademark? It gives you nationwide priority as of the application filing date or as of your priority date. So you can file based on an intent to use and based on current use when you do a trademark. So when you file based on an intent to use, and we'll talk about that later in this presentation, when you file based on intent to use, your priority date for use is the application filing date. However, when you file an application based on current use, your priority date is whatever the date was that you first started using your name. And so that is why it's so important to get it on file, because you'd be able to have enforced from a priority standpoint from the date that you first started using, even if you secured the trademark registration a little bit later. And there's the automatic presumption of legal ownership and exclusive rights. It functions very similar to a birth certificate where there's no question that you are the owner, it's undisputed. And so that's what a trademark does. It gives you enhanced remedies for infringement. So you have legal recourse to go against any third parties who are infringing against your trademark. And you absolutely should do that if you were to discover that, because you are able to get treble damages, costs, and attorney's fees. That is something that you don't get if you don't pursue trademark protection. If you do have products, you can get protection against any counterfeit. You also have the right to use the registration symbol, which will basically signify to the public that you are a registered trademark owner. And then, as I mentioned before, you can have the ability to license, transfer, or sell your trademark. And so when is the best time to trademark? Get this question all of the time, so I did want to highlight this again. When do you need to trademark? Before adopting a name, a tagline, or a logo. So before you decide to start using anything, any name, any phrases, anything like that, you want to pursue trademark for it to see if it's even possible, and then also to see if you are infringing on someone's trademark rights. You also want to do it before licensing. So if you have any intentions on licensing, you need to have trademark rights in order to license, because you can't license property that you don't legally own. And the only way to establish legal ownership is with a trademark. Before any brand extension, so if a lot of us, pivoted during the pandemic, so if you're switching gears in terms of like your business offerings, that's a good time to pursue trademark protection to make sure that this new territory that you're venturing into is actually, a permitted area for you to be able to extend into based on trademark, to make sure that you're not infringing on someone else's trademarks by extending into those new territories. Before expanding geographically, that's another thing. You definitely need a trademark before doing that to ensure that your rights are protected beforehand. And then also before hiring any staff, whether that's independent contractors or employees. And so that's inclusive of before anyone starts designing your website or, handling your social media or doing anything related to your business, you want to pursue at least start the trademark process before making any kind of hires or outsourcing anything, because in those situations, your intellectual property is exposed to those who are working with you. So now we're going to go into actually identifying your trademarks. So I'm asking you this, and you can drop it in the chat. Based on this list here, so potential trademarks that you may have are, your business name, logo, tagline, product or service name. There may be an event, a regular event that you do, like maybe it's a workshop or a conference or a summit, or maybe it's a course name. Maybe you've got a podcast or blog name that you're doing. App icons. So like a lot of times you'll see these little icons and they may or may not be used on an app. You could have an icon that you use and you might not have an app service, but I know that they're mostly used on apps. You can actually protect those as well. Also hashtags, you can protect hashtags as trademarks if those hashtags are being used in connection with a product or service. So if you're just using a hashtag on social media alone, that does not constitute trademark rights. So what constitutes trademark rights is when you're using the hashtag on the inside label of a shirt and it's the name of your brand, or it's the name of the course and you incorporate a hashtag. The hashtag must be used in connection with a product or service. So drop for me, based on this list, in the chat box. Let me know, how many trademarks have you identified for your own business based on that list? Just drop it for me in the comments, just the number. You don't have to reveal, anything other than the number of trademarks that you've identified. Okay, someone said 2, 3, 13. Wow. 10. Amazing. Well, yes, that's the thing. So right now we're just identifying the trademarks, but then a little bit later, we're gonna go through and prioritize, because sometimes, even though it could be a potential trademark, does it make sense from a business perspective to actually protect it? Because you might not have intended long-term use. So right now we're just identifying what potential trademarks you have. And I also want to touch on another point. So like you can trademark, phrases. And so it's important to keep in mind that a lot of times, there might be some celebrity sayings or quotes out there that you might want to, that you come across and you might want to incorporate on your merchandise. So maybe you want to include it on a shirt, or maybe you want to include it on a mug or something. It's important in those cases to actually do trademark searches to make sure that those phrases aren't protected. But if these are phrases that are actually connected with a public celebrity or figure, you can't just use those phrases all willy-nilly in connection, with your products or services without getting permission from the person who has the quote or the person who owns the intellectual property. So that's just something I wanted to mention, because I do see that often people just think that because it's a celebrity and they use the quote that it's free reign, but no, that's incorrect. You generally have to get permission to incorporate certain phrases and things of that nature on any products or services that you're using in a commercial sense. Now, if you're using it in an educational sense, like you're using the quote in a PowerPoint to discuss a certain topic, that's different. But if you're actually making money and profiting off the use of a celebrity's phrase or likeness or anything like that, you do absolutely need to get permission beforehand. Okay. So yes, we did this. We identified your trademarks. A lot of you have identified several of them, which is great. So now I want you to think about, for each of the trademarks that you've identified, what products and services do you currently or plan to offer under those names? So think about your goals. So think about, I would say, your 12 to 24 month goals for your business. Maybe you're currently doing something right now, but you're planning to launch a podcast in early 2022, or you're going to launch a new product at the end of this year. You would want to identify with each of those trademarks, identify what it is that you are providing under each of those. Because as I mentioned, that's what makes it a trademark, is that you're offering, it's the name of the product or service. That's what makes it a trademark. So take a little bit of time to identify what it is that you are offering, and includes current things or anything that you plan to do. Because that's going to be important, as we will cover later about covering in the trademark process, anything that you plan on doing in the trademark applications. Because once you file those trademark application, You can't go back in and say, oh, I forgot, let me add in. You can't do that. You will have to file a completely new application for any additional items. So it's always best to be over inclusive. And we'll talk about that a little bit later. So just take a moment here to just identify all the products and services that you currently offered and anything that you intend to offer within the next year or two. Are there anyone drop in the chat for me? Is there any future product or service that you are thinking about doing that you aren't currently doing? Just drop something in the chat for me, just so I can know that you're here and you're listening and taking it all in. Okay, so here, design packages. Yes, you do need to make a chart. It is helpful to make a chart, and I actually included charts in my book, Trademark Like a Boss. If you haven't gotten it already, I include a lot of charts and worksheets and stuff in that book because, yeah, you need to really break it down. So I hear you totally. So let's think about this, prioritizing your trademarks. So you might have identified quite a few potential trademarks that you have. But let's prioritize what is actually really important right now. Because even though you might have 10 potential trademarks, which are the ones that you should absolutely pursue protection for? And so I want you to ask yourself, am I in love with it? So out of the ones that you've identified, are you in love with it? Like you are just so excited, you love the name or you love the logo, like it's something that you are just really excited about and really feel that it signifies, your business and your purpose and your mission. So that's the first question I want you to ask yourself. The second one is, how would you feel? How would you feel to find out that somebody stole it? Like, what kind of emotion would that conjure up inside of you? Anger? Would it make you angry? Would it cause you to be really upset and potentially lose out on business if someone were to steal that name or that logo? So think about that. Also ask yourself, is it your primary offering? So if it's your primary offering or the primary business focus of your business, that is definitely something that should be prioritized and protected. And then the other question I want you to ask yourself is, does it currently or have the potential to make you money? So ask yourself, is it currently making me money? Because a lot of times the trigger for a lot of business owners is that, oh, I'm making money now, let me go trademark. Even though the ideal time is to trademark before you even open for business, the reality is that a lot of business owners wait until they start making money and then they're feeling really good and optimistic. So think about it. How are you making money in this? If so, definitely want to prioritize getting that trademark because it's already out there. You're already using it. So you're exposed right now. Then the other question is there something that you're looking to do that has the potential to make you a lot of money and have a lot of exposure? Then that is also something that would be high on the list of getting trademarked. And then secondly, or fifth, not secondly, actually I'm at number 5 now. Number 5, do I plan to use it long term? So that's a big question. So if this is something that you only foresee, let's say you're doing like a 6-month campaign or something, then no, it's not worth pursuing trademark rights for. But if this is a long-term thing, like your business is looking to be long-term, then you do want to pursue trademark protection for that. If it's going to be short-term, and I would say anything less than a year, then it's not necessarily worth pursuing the trademark rights. Because once you do get the trademark, as I mentioned, the renewal, the first 10 years, between year 5 and 6 of the registration, you have to file the renewal. And the reason they require the renewal, like between year 5 and 6 after getting the registrations, because a lot of businesses don't survive 5 years. So they don't want those trademarks to sit on the register for, and they're not being in use. So there is, that 5 and 6 year point where you have to file renewer paperwork. And so if you're not going to use it long term, there's just no sense in filing for trademark protection. So hopefully these 5 questions are helping you really kind of reevaluate and prioritize what are the most important things that you should be focused on right now. Okay, so now we are going to do the trademark searches. So there are 3 components to doing a manual search. You got to look at the US Patent and Trademark Office database. We're going to do a common law search, and then we're going to do a domain name search. So we're going to start with the USPTO search. And so I'm gonna close my screen and also pull up the search engine on the USPTO site to kind of walk you all through like what that entails. Now I do want you to recognize that this is not the thorough, comprehensive search that you would get when you work with an attorney, but it is a good starting point for you to at least be able to identify whether or not there are any red flags that could prevent you from registering the mark. And so when we're doing these searches, we want to look at direct matches of the names, similar matches, and so that's any obvious or plural variations, misspelling, sound alike. So you want to look at not only like visual similarities, but phonetic similarities. So a lot of people think just because they might change a letter or something in a word, if it's pronounced the same, it's still treated the same by the USPTO for purposes of determining whether there's any conflicts. And also English translation. So if your proposed name or trademark consists of a foreign word, you also have to search for the English translation of that foreign word. It's called the doctrine of foreign equivalent, where they look at what is the English equivalent for these foreign terms. So, but before we can even do a search, we have to identify what the relevant goods and services you would need to search. So when you're doing a trademark search, you are focused on use of the name in connection with specific products and services. So I'm going to close this real quickly and pull up the trademark manual and walk you through what that is. So the trademark manual is here. So this is on the USPTO website. And this manual is what basically it's a huge catalog of like how to find the correct classification and description that you would need to not only search for, but include in your trademark application when you file it. So for example, in my case, I do legal services. So, I would go in here, legal services, and find the best description to look for. So I find for legal services falls on class 45. It falls, this will be the best description. And it's always best to use like broad terms versus more narrow terms, so you can ensure broader protection. So if you're doing like cosmetics, for example, cosmetics fall under class 3. So that's where you would find it. But if you're doing something specific, you can also look for that. So you could throw in the chat for me, just like what kind of services or products are you offering? And I can go through the manual and identify them. So just drop in the chat what product or service that you are offering, and we can pull it up in the manual and see what the classification could possibly be. Yes, so for retail always falls under class 35. So it's like I always do. So if you are online retail store, so it'd be online retail store. And so these are the ones. So usually I do the online retail store services featuring, and then you have to specify like what your store features. If you're doing in-person, so if you have like a storefront too, then it would be retail store services and online retail store services featuring, and then you'd have to specify what items you're selling. So it'd be like featuring clothing, home goods, things like that. So for home fragrances and home decor, so then you have to like specify home. So what kind of home decor? Is it pillows? Are we talking about curtains, blankets? When you have like broad categories like that, you have to basically identify each of those items, unless you can, but you can broadly cover them under online retail store services, or you would have to identify each individual item. So let's say if you have like throw pillows, that's going to be one separate trademark class that's there. If you've got blankets, that's another trademark class. And so we'll talk a little bit about what that means when you have all these additional classes. Candles is in class 4. So candles is in class 4. Brand management. Yeah, brand management, I believe, falls under class 35. But as you see, you just kind of put in what you're doing. Yep. Branding, services, namely consulting, development, management, and marketing of brands for businesses and or individuals. So as you see, these are like broad classifications, and it's best to be broad versus narrow because it ensures that you have like broader protection. So question, what if it is a website that provides information for a specific industry? So yeah, so basically that's another option. So like you can do, so there's a one that says providing information about, so let me see what the description is. So there are things, so there are options. So providing financial information or there's different classes depending upon what the nature of the information is. Providing information in the field of diabetes, providing information in the field of whatever. So those are an option. And there's also a website providing, I think there's a description for that. So you'd have to specify the nature, providing business what information via a website, providing entertainment information via a website. So it's all dependent upon what the nature of the information is that you're providing. That's what will determine the class. But in any event, I did want to walk you through this manual because this will help narrow down and help you like get clear about what you need to search for, what are the classes that are at issue when doing the trademark search. So we're going to go back here and then, so the next, so I gave an example here. So we think about Starbucks. So Starbucks has several trademarks. They have Starbucks for coffee and restaurant cafe services. So they have protection for coffee in class 30 and restaurant and cafe services in class 43. So when you do these different, when you apply the example of like making sure you're considering different variations, here's what I mean by that. So again, I'm going to go to the USPTO search site now. So this is the search page, tmsearch.uspto.gov. This is where you go and see if anyone has any prior trademark rights that would cause any issues for you. There we go. Here we go. Okay. So as you see, look, we put in Starbucks, and of course there's going to be, you know, as you see, several trademarks. But look at this. What a lot of people do, they think, okay, well, I'm going to put in Starbucks because with an X. Nothing comes up. So they think, oh, it's available because nothing came up, but they provide coffee. And because they put in Starbucks, as you see, it didn't pick up the CK in Starbucks. But from a trade, that's why it's important to do different variations, because even if you do, let's add in another B in Starbucks. No, oh, it's available. We all know that Starbucks has, as you saw, over 92 different trademarks. So that's why it's so important to consider different variations of your name when doing the search, because as you see, if it's not a dead on, it's going to show up as, oh, it's available. And so I always have to like do different variations. So like for I'm Radiance IP Law. So I would like search, like if you search Radiance, it's going to be like hundreds of, names. So then I'd have to narrow it down because those aren't in IP space, Radiance IP Law. And then there we go. So this is just to show you, just to, do different variations of the name, and just don't assume that it's available because there wasn't a specific dead on hit. So hopefully this makes sense to you. Okay. Is there a same rate with the USPTO? This is a question. Is there a same rate with the USPTO for one as it would be for Starbucks doing the 93? So, so the way it works with the USPTO, you have to pay filing fees. The filing fees are $250 per application per class. So if that's what you're asking, if it's the same like rate in terms of cost, no. Each application fee, there's an application fee for every application, and then you're paying per class. So if you're doing a multitude of different things, and let's say you have 3 trademark classes, that's 250 times 3, or 250 times 4 if you have 4 classes. So you do have to pay per application, per class, and you do have to file your trademarks in separate applications. You cannot put all of your trademarks in one application. So I hope that answered your question. So another part I want to show you, so to give you an example of what I did with my name, so with Radiance IP Law. So there's a way that if you're doing a search, and let's say you do like I did with Radiance, and you saw there was like 200 things that came up with Radiance, because there's like Radiance for everything. Like there's Radiance for, so like everyone uses Radiance, except in the legal field, that's mine. But if you go and you do a search and you see like hundreds of hits, I'm going to show you how to narrow it down. So I'm going to go back and just show you how to quickly narrow it down if you happen to have a name that there are a lot of users. So you go to this free form here. You go to this free form, you're going to type in the name of the mark. So in my case, I'm just going to do Radiance, not Radiance IP Law, just do Radiance. And then we're going to do we're going to do goods and services, and that's legal services. And we're going to see how many Radiances come up for legal services. Oh, that didn't work out. Uh-oh, what happened? So let me put this in again because something's off. So this pops up, mine. So as you see in the legal space, there's only one Radiance mark. And so I had to narrow it down to be able to see it. Otherwise, as you saw when I did the other form, and I just put Radiance in there are 295 records. So essentially for me to see whether there's any conflict, I would have to click through all of these and see what are you like, what are they offering? Are they in the legal field? You know, it's time consuming. So instead of like going through, I say if your search reveals like more than like 20 or 30 references, it would, you know, be good for you to just narrow it down and do the free form or do the structured where you can narrow it down to the name and then the products that or services that you're offering. So that's just a little trick if you find yourself with a lot of like references coming up to help weed them out. So when you're looking through and looking at the search results, you will want to write down any similar identical trademarks covering similar identical goods. So anything remotely related to what you're doing, you want to write that down and dig a little deeper. Because for trademark infringement, you got to consider what we call a likelihood of confusion. That's the standard. And so what's the likelihood that if your prospective clients or customers saw your name, your business name, and this other third party's business name in the marketplace, would they think that they're actually the same business, related, or some kind of endorsement? And so you'll want to write down anything that comes up on the register and consider like whether this will, you know, cause some risk for you. So then once you do the trademark search, so once you do the USPTO search, if there is a red flag, if there is something glaring and dead on to what you're doing, you can stop right there. You don't even have to do the other searches, because it's like that seals the deal. If, however, you've done that search and you haven't really found anything glaring, then you should move on and doing what we call common law search. And so that's going on to Google, looking and see who's using my name and doing what I do. So like the example here is like Starbucks and coffee. Mine would be Radiance and legal. And so you'd want to do those searches and see what comes up. You'll want to look on social media and see, is there somebody on social media using this name already? If you're selling products, you'll want to look on Amazon. You'll want to do a search on Amazon and see what's out there. If it's a business name, you can also search the Secretary of State to confirm name availability. But I do want to highlight that a lot of times people mistakenly believe that because they were able to put their name into the Secretary of State business records name search and nothing came up, that it's available. But that is not a trademark search. That is just one aspect of the trademark search. So just because you're able to file with your state does not mean that your name does not cause any trademark concerns. But it is a part of the due diligence that you would do before adopting a name. And then once you've done this common law search, you'll want to write down any red flags that you come across. And then you'll want to look at domain names. And so domain names is mostly to see, is there anyone out there who is using the URL and then offering a similar product or service on the website and that incorporates the trademark. It's not so important that someone else already has a .com if the page is blank, because as I mentioned before, just owning a domain name alone does not establish trademark rights or any legal ownership, but it can influence whether or not you want to use something if the .com is not available. So, but this is a part of the search, is like looking at the domain and thinking about different variations. So if my first choice isn't available, what are some ways that I can maybe change up the domain name a little bit so that it fits your needs? So now once you have all your results in front of you, you'll want to review them. So, and ask yourself these 3 questions. Is the mark protectable? So meaning, is it a name that is unique and distinguishable, not descriptive? Is it protectable? Is the mark available for registration in the United States? So were there any prior trademark applications or registrations on the USPTO that would hinder you from securing trademark rights? And then the other question is the mark available for use? So those are kind of 2 separate questions. Is it available for registration and use, or it might be available for use, but maybe registration would be a challenge. So these are 3 separate questions that you'll want to ask yourself. Is the mark protectable? Is it available for registration? Is it available for use? And so the standard, as I mentioned, is likelihood of confusion. So that looks at, what's the likelihood of any confusion? Did you identify any problematic references on the USPTO? If you did, meaning, and what I mean by problematic references is that they would hinder you from registering, then you don't even need to bother with doing the other searches. But if there seems to be relatively low risk, then you can go and do the common law search and then do the domain name search and then do this like final assessment to determine for you whether from a business perspective it makes sense to move forward with the trademark process based on this research that you've done. So this search is super important part of the process, because a lot of people just go and like file their trademark, they don't do any search, and then they get a likelihood of confusion refusal. And so this is something they could have found out that there was going to be a problem before starting the process if they had actually, stopped and did the trademark search beforehand. So this will save you a lot of time and money. Even though it's an additional step, it will save you a lot of time and money, in helping you determine, what's the best next step for you. And in fact, the reality is that 70% of trademark applications receive an initial refusal from the USPTO. So there is a chance that you will receive a refusal, but the question is, do you have the ammunition? Are you in the position to actually get around those refusals if it were to occur? So now we're going to go into, and again, if you have any questions as I'm talking, feel free to drop them in the chat. We're going to go into filing your application. And so I'm going to walk through kind of what you need, and then I'll actually try to walk you through like what completion of the trademark application looks like. So when preparing to file your application, you'll want to determine, okay, what mark am I going to start with first? Because as I mentioned, you have to file each trademark separately in each application. So I always suggest starting with basic word marks. Don't file for anything stylized or designs or anything. And the reason why you should file for basic word marks is because that gives you the broadest protection in all forms and variations. So as a starter, if you have not filed any trademarks yet, you want to start with basic word marks. And so the example on the slide is Coca-Cola, just plain wording, no stylized, nothing. If you have logos, that is also a consideration too, where you can file for your logos. So you can file for stylized, as the case shows here with Coca-Cola. They also have the logo with the Coke bottle on it. That's another separate trademark that would be under a separate application. You can file for design mark in black and white, or you can file for it in color. I usually file for my clients design marks in black and white because that gives them protection in all colors. So regardless of if they change up the colors or they discover that someone else is infringing on their rights and that they're using it in a different color, they would have protection in that. So I always file in black and white. I don't think I've ever filed for a color logo. So there are two ways to file the application. So you can file based on current use. So if you've been in business and you've been using your trademark, then you would file based on what we call 1A, based on current use. If you are preparing to use something within the next year or two, then you can file based on an intent to use. So that's a 1B, and it's based on your bona fide intention to use the mark. So you can file it based on your intention to use something. Even if you don't actually end up using it, in 2 years, it doesn't matter. As long as you have the bona fide intention to use it when you file the application, that is what is most important. Of course, with the intent to use applications, you do have to show actual trademark use, so actual evidence of trademark use, and you have to start using the trademark before the USPTO will issue the trademark registration to you. So when filing based on current use, here are the requirements. So you want to include the applicant's name, so that's a trademark owner. It's best to file under the business name because, as I mentioned earlier, trademarks are a business asset. So for the applicant's name, you'll want to list your LLC or corporation as the trademark owner name. You'll want to include your mailing address and email address for correspondence. So for the mailing address, it's best to use a business address because your address becomes a part of the public record. So you'll want to use a business address when filing the application. And you'll want to include an email address that you actually check regularly because any and all correspondence from the USPTO is going to come through your email. The only time you'll get something in the mail is after your trademark registration has been registered, the USPTO does mail your US trademark registration certificate. But other than that, throughout the process, all correspondence will be sent to your email. So you have to include an email that you check regularly. If you're filing for a logo, you have to include a clear image of the mark. So like a clear graphic, black and white graphic of the actual logo mark that you are applying for. And so for logos, it's important to note, you must use it the same way at all times. So if you are applying for the logo, it must be used that same way at all times. If you ever change or tweak anything in that logo, then the registration application becomes obsolete and you have to start the process over. So with a logo, that's why it's important that you are making long-term use of it and you're using it consistently, because a logo, you get protection for exactly the image that you have submitted to the USPTO. Then you'll have to include a description of the goods and services. So the description is just as I mentioned from the manual. The manual helps you come up with the proposed goods and services. So you'll have to have an idea of what you are getting protection for to complete the application. You'll also need the data first use anywhere and the data first use in commerce for a use-based application. So what that means is, so basically sometimes the data first use anywhere may be different from the date of first use in commerce, or sometimes it could be the same. So, but in any event, there are two dates that you have to provide. And so meaning data first use is anywhere that you've used it would be considered the data first use anywhere. And then once you actually start using it in commerce, so actively marketing your products and services across state lines would be considered the date of first use in interstate commerce. And so we would need those dates. And then you'll need what we call a specimen of use, demonstrating use of the mark in connection with the goods and services that are included in the application. I'll provide examples of that a little bit later, but essentially it's evidence of that use of the trademark exactly as you've applied for it. And then you'll also need your filing fees. And so for the TEAS Plus application, and so I'm going to show you the TEAS Plus application. There are two types of actual applications. There's the TEAS Standard and the TEAS Plus application. I tend to always do the TEAS Plus application for my clients because it's more streamlined and straightforward. But there is also the TEAS Standard application, which has a higher filing fee attached to it. But for purposes of this presentation, I'm trying to show you the most streamlined way to move forward with the process. So if you're filing based on intent to use, there's less things that you need. So as I mentioned, you need the business owner's name or the trademark owner name, mailing address and email, same rules apply, business address, a regular email that you check for correspondence. For the logo, you need a JPEG image, black and white image of the logo. You need a clear description of the goods and services, the filing fees, and then later in the process, you should anticipate having to file a statement of use showing evidence of once the trademark's in use, and then for that there will be an additional $100 per application per class when you file that specimen of use. Or if you have to keep extending your application because it's not in use, you should anticipate to pay $125 per application per class for each extension that you file. You can file up to 5-6 month extensions of time for intent to use applications. So you can actually extend an application up to like 3 years. Like there's actually an application that I filed back in 2018 that was based on intent to use that we are just now coming up on the end of the 5th extension. So as you see, like you have a long period that can be covered. So there are rules to like what types of specimens you can use and what will support your use for the USPTO. So there are some specific rules. And so when you are applying for products, for example, so if you're applying for candles or t-shirts or things like that, you need to show evidence of use of the name or the logo, depending on what you're applying for, on the actual product label. For t-shirts and like, you know, clothing and apparel particularly, you need to show use of the name on the inside tag. So if you're, for example, selling a Fruit of the Loom t-shirt and you just have something slapped on the front, that's not considered trademark use. You're going to get a refusal for that. For it to be considered trademark use for clothing and apparel or any kind of products, it needs to be on the packaging label or in the inside tag. You can also show a web page showing the product on the page and then how to purchase, because there's certain products that you can't, I guess, put the actual name on the product. So like I had a client that made these like really big, what is it? It was like a really big product that it was like an industrial product where you don't typically slap the trademark on the industrial product. So we had to submit an image of that industrial product on the website showing how consumers can purchase this product, and that was sufficient for a specimen. And then you can also include product instruction sheets or instruction manuals that are included with the goods. That's also evidence of trademark use. For services, I feel like for services, it's a little bit easier, but because you can include, if you have a web page showing and describing your services near the actual trademark, you can provide website screenshots, marketing materials, print advertising. If you have a storefront, for example, you can include, or like a dive clients who had a fitness studio, we included photographs of the front of the fitness studio or the front of the storefront. So there are different things. So here are just a few examples of acceptable specimens. So as you see here with the shirt example, and that was a hashtag mark. It was used on the inside of the t-shirt. And so that constituted trademark use. And then on the storefront, we took a picture that showed use in connection with the fitness studio. For any services, you can provide a website screenshot showing the services page. And then things like candles and stuff like that, you can also include images of the candle, you know, images of the brand on the candle or on the bottom in some cases. So now I'm going to walk you through kind of at least a part of the trademark application process. So we're going to go to the USPTO website. We're going to click on the initial forms that you will use to start the process. So we're going to go to teas.uspto.gov. We're going to go down to initial application forms. And as you see, there's there's TEAS Plus and TEAS Standard. You're going to start your application in TEAS, and we're going to do, oh, it's making me sign in. Okay, great. So yes, so that makes you do all this signing in stuff when you do go in. So let me sign in real quickly for you. Yeah, so you will have to do this too. Even though I was just on the site earlier today, they make you do a authentication code every time you log in. So here we're going to do a TEAS Plus application. So here at the top here, you see TEAS Plus, and then you see the option for the TEAS Standard. And so as I mentioned, that one has a higher filing fee, $350 per class. TEAS Plus has a $250 per class. I'm always trying to, you know, save my clients money, so we go with the TEAS Plus. Is an attorney filing this application? In your case, if you're filing it, you know, I guess we would call pro se or without an attorney, you would say no. If you're hiring an attorney to do it, they will file this on your behalf. So you wouldn't even have to worry about this. They would do this, all of this information. So here you can see the initial application. So you would put in the owner. So put in the owner, and I'm just kind of walking through just to show you. Uh-oh, what just happened? All right, looks like the USPTO site is acting funny, so we'll try it again. Hopefully I can walk you through today. Okay. Okay, so you're going to put in your owner name. As I mentioned, it's best to do a business name because it's a business asset. You have to indicate the entity type, so corporation or LLC, and then you have to indicate, once you select, they're going to ask for like where, it seems like every time I click something, so I'm not
I
going to click
wonder,
anything.
Radiance, is it because you have that, because it's saying something about you have another window open? Is it because you have that trademark electronic search window open, maybe?
Maybe, let me,
Okay.
yeah, maybe. Let me give it a try. But if it doesn't, I'm just not going to click on anything and I'll just scroll through. Hopefully we'll be okay. Okay. So, but I did want to get through to the next page so I could show you like the other stuff, but I'll show you as much as I can. So you have to type in the owner, identify the nature of your company and where you are incorporated. Put in your mailing address. So as I mentioned, it's going to be a part of the public record. So it's best to have a business address. I know some people have like a UPS box or something. You can use an address like that. If you do have a PO box or something, the USPTO does require you to enter a domicile address. So they're going to require you to enter in a domicile address that's not going to be publicly viewable. So if you have an address that I guess is like more of a PO box or something, you can put that as a mailing address. But if you are required to also include a domicile address in addition to the PO box. Then you'll have to include the email address at the bottom. I'm going to see if I can type in stuff to see if it'll let me go click over to the next page, just so I can show you what to expect. Oh, okay. It's not letting me do it for some reason. Sharing the same session. Yeah, I closed it, so I'm not sure what's going on. Okay. Okay. Well, my plan was to kind of walk you through, but it looks like it's not letting me do it right now. So I will go back. So once you get through the application, you will go and you will submit your payment at the end. Once everything is complete, you should receive a confirmation email from the USPTO confirming that your application has been filed. So if you go through this process and you don't receive an email, that means you haven't submitted something. You either maybe clicked and signed, but you forgot to submit your filing fees. So you want to look out for a confirmation email from the USPTO once you've submitted the application. So as I mentioned, over 70% of trademark applications receive an office action. So it used to be, I would say pre-pandemic, it was about 3 months after the application is filed, the PTO will examine your application and see if there are any issues that need to be addressed. Now with the pandemic, it's actually been delayed to between 5 to 6 months before your application will be examined. And so they'll look and see, are there anything that needs to be corrected before your application moves forward in the process? So sometimes it could be really like simple issues like, oh, you need to revise your identification of goods and services because you designated the wrong class, or maybe your original specimen was incorrect and you need to submit a better specimen. Or other times it could be that you need to disclaim a certain word that is descriptive as a part of your trademark. So like to give you an example, so for Radiance IP law, I have a federal trademark for that. I had to disclaim the wording for IP law because I can't claim exclusive rights to use IP law. So sometimes you will have to disclaim any descriptive wording that's a part of your trademark. And so that just means I don't have exclusive rights to IP law separate and apart from Radiance IP law as a whole. And so those are some simple, I guess, issues that may arise with your trademark application. More complex refusals, however, are those that will require research and arguments and all of that. And these are more of like the likelihood of confusion refusals. So if they've cited a prior similar trademark or registration, that is an example of a complex issue. Descriptiveness, if something's found to be descriptive or geographically descriptive or deceptively misdescriptive, those are also more complex. More increasingly, the USPTO has been doing does not function as a trademark refusals. They've been doing that a lot. And so if you get any of these refusals, that is code for it's time to hire an attorney, because these types of refusals require legal research, brief type responses to get around. So this is something that you can expect in the process. So when you do get an office action, you have to file a response within 6 months of receiving the response. So you receiving the office action. You have 6 months to respond to it. Sometimes it's helpful to, if you receive something and something seems a little funny or off and you're not really sure what's going on, sometimes it's a, you know, to your benefit to call the examining attorney and just ask some clarifying questions. It's important to note, however, that the examining attorney is not your attorney. They cannot give you any legal advice. They cannot provide you the how-to or the strategy. So the examining attorney is actually basically the judge. You can view them as the judge in this instance. They're the ones who are judging and have the final say over whether or not your application will get through the registration process. So that's how you should view them. They are not your attorney. They're not providing you with any advice or strategies or anything like that. But it is sometimes helpful to call them when you do get an office action, just to get some clarification on certain points. So assuming you are able to overcome any refusals that, you know, may arise and you're able to get and overcome, you know, the office action response, the next phase is what we call the publication for opposition phase. So during this 30-day window, your trademark application is published for opposition in the official Gazette. So any third party who believes that they would be harmed by your registration, because they have prior trademark rights, they can oppose your application. And so an opposition is basically, I guess you could say, an administrative proceeding before the U.S. Trademark Trial and Appeal Board. So it's similar to litigation, except you can't win any damages or anything like that, but it's a lengthy process like litigation and can be expensive, and it determines your ability to register a mark, not use it. So if someone wanted to prevent you from using something, they would have to sue you in federal court. So the opposition proceeding is only to prevent you from registering a mark or challenging your ability to register. So this is also a step in the trademark process. If no opposition is filed, then great, you're in the clear. If you file based on current use, then the next step would be registration, and you can look out for a registration certificate. If you file based on an intent to use and no opposition was filed, then the USPTO will issue a notice of allowance, and then you have 6 months to file a statement of use. And the statement of use is when you file the evidence of trademark use in the marketplace. And if you have not started using by the first 6-month deadline, then you can request another 6-month extension of time, and you have up to 5 times that you can file an extension with additional filing fees. So approximately 2 months after the filing of the statement of use, you will get your beautiful, shiny registration certificate in the mail. So yeah, you would receive it in the mail. And then you would look out for that. They will not email you your certificate, and they won't actually email you when you've been registered. They just send it in the mail. But you can check the records on the USPTO, and I can show you that actually now about how to check on the status of your mark. So let me close this out again. I can pull up how you can check the status. So here is tsdr.uspto.gov. Like this is how you can basically search and look up the record for anything. So let me, I'll pull up my own registration just as an example. So I can go to TSDR and you can pull up here, and here is where you can see the status. So here you can see, you know, when the application was filed, you can see when it was registered. You can also see, this is also where you can get copies of the documents. So the registration certificate is in here. Like this is all part of the public record. And so you would go to tsdr.com to pull this up, and you'd also see your next maintenance deadline. So my next maintenance deadline is coming up next year, where I have to do the, like I said, the 6-year filing. And so you can see when your maintenance deadlines are here. So the TSDR is very helpful on the USPTO to check the status of your applications and stuff like that. So as you see, the trademark registration process is quite, can be quite lengthy. So on average, it's about a year, but as you can see, if you file based on the intent to use, it can be much longer than that. So, but right now I would say it's about a year, especially because of the delays that are going on. And then once you are registered, you have it as long as you use it, and it's renewable every 10 years. And the renewal period, the renewal process is a lot quicker. It's basically like the statement of use where you just have to submit the evidence that you are still in use. So you have to provide evidence, hey, I'm still in business, here's my website screenshot, and that's the renewal. So you don't have to go through this lengthy process again, unless of course you're filing a new trademark application because you've added some additional goods and services. But once you've secured that registration, you are in the clear, meaning you're registered and protected so long as you continue to file the renewal paperwork. And so it's important to note, beware of trademark scams. So once you file with the USPTO, your contact information is on the public record. So there are a lot of like false solicitation documents that come in where people are emailing or mailing saying, oh, you owe us $2,000 to finish your process. Don't fall from those. As I mentioned, you want to make sure any and all correspondence from the USPTO is going to be sent from their official email ending in uspto.gov. If you receive stuff in the mail, aside from their trademark registration, ignore it. It's spam. It's just a way that people are trying to get money from you. So just know that any and all correspondence from the USPTO is going to come in your email, with the exception for the trademark registration certificate that's going to be mailed to you. So here's just the page highlighting a few of the pages that I referenced. So uspto.gov is the official US Patent and Trademark Office website. If you're looking to do a search for any pending and registered marks, you would go to tmsearch.uspto.gov. If you're looking to file applications or any documents, so like the office action responses or any documents, you go to tas.uspto.gov. If you want to check the status of your application, you go to tsdr.uspto.gov. That's just where I went. And then if you want to check the Trademark Trial and Appeal Board records, so that's the records for any trademarks that are currently being or have been in the past opposed or canceled, any basically proceedings you'd find on the Trademark Trial and Appeal Board records. And then you'll want to check trademark fees because USPTO does routinely update its trademark fees. And in fact, earlier this year on January 2nd, they actually increased their filing fees. It was a little bit, I think it was $225 for the T's plus per application, but now, and per class, now it's $250. So they do periodically raise their filing fees. So you do want to check to make sure that they're, that you're aware of what their fees are. So now we're going to go into basically maintaining and enforcing your trademark. So once you become a trademark owner, you have a responsibility to protect your own trademarks. Nobody else has that responsibility. So if you're not protecting and regularly monitoring and enforcing you could potentially lose the rights that you just spent your time, money investing to get. And so that's what we're going to talk about right now. So as I mentioned, you have to file the necessary maintenance documents and paperwork between year 5 and 6 of the registration, and then every 10 years after that. If you miss any of these deadlines to file, they will cancel your registration. So the USPTO will cancel your registration, and there's no way to revive it once it's been canceled. You'd have to start the process from the beginning. There are certain rules that you should be aware of in terms of what constitutes proper trademark use. And so one of them that I often see, you want to keep in mind that trademarks are adjectives, not nouns or verbs. So the example I provide here, use a Xerox copier, not Xerox these copies. A lot of times we are basically turning people's trademarks or using them as nouns and verbs. So people like say, Google me, or, hand me a Kleenex. Kleenex is not a tissue, but it's a brand name, but we use it as a noun or we're using it as a verb. And so that's something to keep in mind, that you want to make sure that people are using your trademark properly. I know that Google actually has brand guidelines where they're having to regularly police and educate about the use of Google. It's Google search, not go and Google this or Google that. So just something to keep in mind. Also be consistent. It's very important that no matter what brand name you use or logos you use, you have to be consistent and display it the same way each time. I often come across business owners who are like, sometimes they add a dash in the middle, sometimes there's a space, sometimes there's not a space. Use it, figure out whether you want the space in between the words or no space between the words. Regardless, you have to use it consistently. Otherwise, you're basically diluting your own trademark rights. So you have to use it consistently at all times, everywhere. You want to be conscious of the proper designation. I did cover this a little bit on Tuesday about the difference between the TM and the SM and the registered trademark symbol. So for the TM and the SM, it's basically that you're claiming common law trademark or service mark rights in the name or trademark. It basically holds no legal weight whatsoever. Anyone can use it. Anyone can slap the TM or SM designation. It does not mean they have trademark rights. It just kind of I guess it's an alert that you have an intention of trademarking it, even if you haven't. And then the registered trademark symbol can only be claimed by owners of a U.S. federal trademark registration from the U.S. Patent and Trademark Office. So that is the only time you can use that symbol. And most importantly, when you're using your trademark in, text. So like, within text, you want to highlight it, whether it's in bold or italics, and you want to, include the registration symbol next to it. So it's clear that, this is an actual brand, protected trademark, and not just another word on the sheet or on my website. So you do want to definitely highlight your brand and use the registration symbol and or bold or italicize it to emphasize that it is a trademark. And so as I mentioned, you want to enforce your trademark rights. So you want to make sure that no one, once you've invested in the time and money to protect it, you want to make sure that no one infringes on your rights. So you will want to do regular monitoring of that. So a simple thing that you can do is, set up Google alerts for all of your trademarks. So set up Google alerts, and that will at least, allow you to be notified whenever your name is used, like in the news or somewhere. You'll receive a Google alert for that. You do also want to do conduct regular searches on the Google, Google searches to make sure that there's nobody popping up. There are also actual trademark monitoring services, and we actually provide trademark watch services for our clients for the USPTO records. So the US Patent and Trademark Office is not going to notify you or send you an email or notice when someone else files an application for a similar or identical mark to yours. They're not going to notify you. So you're not going to know. unless you have a trademark monitoring or watch service, or unless you are checking the register regularly. Because sometimes there are trademarks that are able to slip through the cracks and become registered because they, kind of finagled the description of goods and services to get around it, even though they are using a very similar mark and they're providing very similar products and services. So you don't want to just rely on the fact that, oh, the USPTO will block it for me. You got to monitor and make sure that nothing falls through the cracks. So you will want to, either yourself regularly monitor the USPTO or hire an attorney and get a trademark watch service to make sure that there's actual active enforcement of your trademark. And if you come across something that just smells a little funny, you should definitely contact a trademark attorney to assess the merits of your alleged claims, because you want to make sure that you're the prior user and all those things before sending a cease and desist letter. And so another bonus thing I want to talk about are international trademarks. So trademark rights are jurisdictional. So the process that you do with the USPTO will not protect you in other countries. It only protects you in the US and in the United States. So if there are any other countries that you're looking to expand to, or where you manufacture, or where you regularly travel, you will want to consider securing trademark protection in those countries, because some countries are first to use, others are first to file. I would say most countries are first to file internationally. So there are two ways to essentially get trademark protection internationally. One is through a system called the Madrid Protocol. There's like 120 plus member countries that are part of that process. Basically, it's a process where you can file a centralized application based off of your US trademark, and you would submit your countries of interest and then pay one set of fees. And then the USPTO will distribute your applications to all of the individual countries for their individual assessments by their trademark offices. So with that process, it'll allow you to streamline it. It's more cost effective, especially if you're filing in multiple countries. And you only have to hire local counsel if there is an issue with your application. So if there is an issue with your application, you will have to retain local counsel to respond to any office actions. If there aren't any issues, then you should be okay. So a US-based attorney, we do the Madrid Protocol process for our clients. We can help with filing international through the Madrid Protocol. For any countries that are not covered in the Madrid Protocol, you'll have to hire foreign counsel to file trademark application in another country. You'll have to hire counsel. Similarly, if there's someone who's based internationally, they have to hire US counsel to file a trademark application for them in the United States. They're not able to file their own application the way that US based citizens are. So I hope I've, given you a lot of information today. Hopefully you're ready to take action. If you're looking for more information and prefer to have more charts and worksheets and stuff, my book, Trademark Like a Boss, is a great option for that. I've included a lot of worksheets in there and templates and charts that will help you visualize everything that I've spilled out to you today. If you listen to this and be like, what the heck, I don't want to even bother, I just want to hire the professionals, you can certainly schedule a strategy call with me. I'm offering an exclusive promotion to you all for $50 off using the promo code MBDA. It is good through tomorrow, April 30th. So if you use that code, you'll get $50 off a strategy session with me, and we'll go over a customized trademark strategy for your business. I'm happy to answer any questions that you have at this time.
So Radiance, there's a couple of questions that were in the chat. So one of them was my question. So the slide where you have the rejection, you have the two options. When you get the rejection, is that what it will actually say?
No, the reject, meaning that what the office action will say if you get a rejection.
Yeah, you had two categories up there. So when you get the letter, is that what it would say?
No,
Okay.
no. So it will say, you know, here are the issues, descriptiveness, revised identification of goods and services. It's going to actually say what the refusal basis is. That's what the office action will include. It's not going to, I just kind of broke it down in that way, just from like a consumption way. Like there are some quick fix issues that you can do, and there are more complex issues that will require an attorney to address. But it wouldn't break it down like that.
Okay.
Yeah.
And then there was the next question that is, it says, when you are checking the status on the TSDR, is that just for the active trademarks? How do you check that an application has been submitted?
So if you submitted an application and it's been more than a week, it's been at least a week, like basically when you file an application, the USPTO will assign a application number to you, but you won't be able to see that number in the TSDR until like at least a week after you filed it. So you can, as long as you have like either the application number or the trademark that you're looking for, you can pull anything up on the TSDR, and you can pull up dead marks and live marks.
And I think there was one more about someone, they wanted to book the strategy session. So in terms of the $50 off,
Yeah.
they have to book it, but they can schedule it for later. Is that how it would work?
Yes, you can schedule it now. Yeah, it doesn't have to be, you can schedule it for whenever, you know, the time provides on my calendar. I can include the link in the chat. But yeah, it's as long as you schedule it today, you can get the $50 off. We're not going to clearly have the session today, but yes, you can schedule it when your schedule permits.
Okay. And if there are no other questions, I want to thank Radiance for her time for these 2 days. I hope that the sessions have been informative to everyone. So what we do, I do have a couple of sessions, 30-minute sessions with Radiance, but in order to receive those, I'm going to send out a survey. You return a survey and we'll randomly select for those 2 sessions with her. And also in terms of the videos, we will put it up on our YouTube page. It'll be and I just put the YouTube link in there in case you don't have it. But if you look at the bottom of the email that you received for the session, you will see all our social media links in there. And so those will probably be up sometime after May 15th. And we will have some of the other classes up there. And we'll be posting more of the events more of the sessions that we did from earlier throughout this last year will be posted on that website. So you can go there and get the information. And are there any other questions? Okay, I take that there are no other questions. Well, everyone have a good evening. And once again, thank you, Radiance, and thank you everyone for attending.
My pleasure. Thank you all for joining today. Hope you enjoyed it.
Good night.
Good night.